What's up, CAP? This is Debra Rainey, the compassionate lawyer, coming at you again with my response. As I said to you in the initial response, it's my hope to provide legal information for those artists who find themselves in legal quagmires, legal situations where they're not sure what rights, if any, that they would have. I want to send a special shout out to Miss Ariel Johnson, the blog producer. Ariel, thank you so much for including me and allowing me to reach out to your artists and help make sure that they understand and know what their legal rights are. So this response is related to the designer young lady who had some issues where she was contacted by an artist and asked to create some special products for him. The agreement, from what I understand, was that that the artist people didn't guarantee her that they would contract with her, but they wanted to see what she could do. So she created 3 hats, spent money out of her own pocket, and sent it to the artist. The response she got from his people was that they decided to go with a different design, and they didn't choose to use her stuff. Then they asked her to create another specialty item of some sort. She created that design, once again spent money out of her pocket to purchase the necessary materials, put the item together, and sent it off to the folks. Her response that she got from them as a result of that second request to make a specialty item was that that's not what they were looking for. It wasn't what they had envisioned for the artist. And once again, she's out of money, having responded to that second request for the specialty item. Well, let me say a few things here. Under the law, absent a contract or an agreement of some sort that 2 sides have made, there's really not going to be a way to get recouped for your losses. The first scenario with the designer, where she made the 3 hats in anticipation of or hopes of enticing the artist's people to hire her to be their designer, knowing that there was no guarantee they would do that, their law's really not going to recognize any loss on her part that would allow her to bring a lawsuit. And let's be real, the $150 that she's out of pocket in order to hire a lawyer to even investigate the possibility of a lawsuit of any sort is going to cost her 10 times more than that. So that's first scenario, where she sent those 3 hats in, hoping to entice them into using her creations. There's no legally recognized loss there. That's unfortunately the cost of doing business. You guys got a response from my producer, Renee Norris-Jones, who is the business manager for my office, does the marketing, the consulting, and everything else. And she's also a consultant to most small business owners here, to a lot of small business owners here in Philadelphia and across the nation, actually. And she ran her own business for a number of years. So she provided a very concise and sort of in-your-face response as a business consultant. Legally, that first scenario, understand, there is no legally recognized loss. I mean, unfortunately, when you go in there knowing that maybe perhaps you're going to entice them to buy your products and they don't, you knew that going in, so there's no real loss here. Yeah, you went out of your pocket to spend that $150, which would have been a good business move anyway, because you're trying to demonstrate to these folks why they should pick you. So you're going to go all out and put your best foot forward. But do that going in knowing what the potential outcomes can be. One of the things I would suggest to the designer going forward, and others like you, if you do that sort of thing and you're in the business of designing and creating and trying to get folks to buy your products, create some sort of a sample contract. And by that I mean just have an agreement with those folks. And under the law, the contract doesn't have to be in writing. A contract can be a verbal contract, so long as there is an agreement between 2 parties to do something. One party does something, the other party does something. There's some consideration between the parties. You got a contract. And what's consideration? Consideration is nothing more than, if I say to you, I sell T-shirts, and I say I'll sell you 10,000 T-shirts in exchange for you giving me $20 per T-shirt. And you say, okay, I'll give you that $20 for a T-shirt as long as you make the T-shirts to my liking. When you agree to give me that $20, that's a consideration right there. Consideration is either paying something of value or refraining from doing something that you would otherwise have the legal right to do. Another example is you got two folks. One person has a service where he or she consults with folks writing grants for their nonprofits, for example. The consideration could be something like this. Okay, you agree to help us write our grant, and during the period you're agreeing to help us write our grant, you don't work with anybody else. The person who does the grant says, okay, I agree with that. That's consideration because he would normally have the right to talk to other people and help them write their grants, but since he agreed with the people he's contracting with not to do that, that's the consideration that he's given. Consideration is not real difficult. It just means something of value was given or someone agrees not to do something that he or she would otherwise have the legal right to do. Contracts don't always have to be in writing, but I would suggest that you put something down in writing to cover your butt. Because if you have to go to court and fight a verbal contract, the only thing the court's going to have to use to determine what those terms were is the conduct and the action of both parties. And if you didn't make it a habit to write down what it is you were doing and the other person did, you're going to have a tougher time trying to convince the court what you thought the nature and terms of the contract were. Unless it's someone that you do a lot of business with, you have experience with, my suggestion to you is to always insist on some manner of a writing. Whether it's a sample contract, I'm going to send you my samples. If you choose not to use them, you'll send my samples back to me at your cost. Or if it's a comprehensive contract, you're going to buy from me, here's the terms under which you're going to buy from me. In exchange, here's what I'm going to do for you. If you're going to get in the business of dealing with other people, I'm going to always suggest that you do a contract of some sort. And oftentimes, maybe the other folks that you're dealing with may have their own generic contracts that they use. If you're going to sign it, read it, make sure you understand it, take it to an attorney, and have him or her peruse it and go through it and make sure you understand the terms thereof. Don't get in the habit of doing business with folks without having something in writing to protect yourself. Having said all that, though, go into this endeavor with your eyes wide open. Unfortunately, for the designer artist that I was talking about when I first started my response, going in the first time knowing that they maybe perhaps wouldn't use her designs should have peeped her to what could have happened the second time around when they asked her to do that specialty creation for the artist and they decided that they didn't like it. Before you do anything like that, make sure you totally understand what all your other options are or what the outcomes are going to be. Let's say you spend $2,500 to make this specialty hat and they decide all of a sudden, oh, it's not what we were looking for. Well, you shouldn't just be out of $2,500. You need to write a contract or have one written for you so that you can protect yourself to recoup at least some of what you put out that you would not have normally put out but for this specialty situation that you found yourself in. It's unfortunate that the artist found herself in that position. I hope that she was able to get her products back. But unfortunately, there's not really much of a legally recognized loss here. I'm not saying she didn't lose anything. Of course she did. And she lost some trust, too. And I understand that there was no honorable mention of her anywhere in the artist's blogs or the Facebooks or anything like that. And I'm sorry that you found yourself in that position, but you got to protect yourself because business is business. And you can't be worrying about who they are and what kind of people they are. You got to put your protection first. If you're in the business to make money and to attract folks to buy what it is you're offering, you have to protect yourself. And the first way to do that is put it down in writing. It's not real and it's not going to protect you as easy if it's in writing. You can do verbal contracts. I do not think that those are a good idea, particularly if you're contracting with someone that you don't have a lot of experience with. Put it down in writing. Call your local bar association. Ask them for the number of an attorney who may look over the contract for you. As I said in the first response that I provided for you folks, check with your local bars to see if there's any nonprofit organizations out there that will give you some down and dirty, free, quick legal information or advice as it relates to contracts. Go online, go to your blog and other places where you might be able to find some sample contracts. And I can make some sample contracts available for Ariel that folks can take a look at and borrow whatever it is that they need. If you need to reach out to me and ask some more questions, reach out to Ariel Johnson, and she can put you in touch with me. Send me your email, or you can email me, Debra at DebraRaineyLaw.com. I hope that this little bit of information is helpful to you, gives you a better idea of where you stand and what your legal rights are. Remember, y'all, put it down in writing to protect yourself. Thank you so much for listening. Check out my show every Tuesday night, www.gtownradio.com. For the people, law in plain language. This is Debra Rainey, the compassionate lawyer. I'm out.